Good afternoon, everyone. We're live, and so we'll go ahead and kick off our presentation. I want to thank everyone for joining us today. My name is Craig Kavark, and I'm a partner, and I head up the group, the Husch Blackwell Employee Benefits and Executive Compensation Group, and want to appreciate and thank you all for joining us. Quickly, just a couple of housekeeping items. At the bottom of your console, you can ask. There's a bunch of application icons, and you can use those throughout the day. If you have any questions, there's a place to post a question. We also have a PDF of the presentation materials that are going to be available under the program materials folder. And of course, if you can't find all that stuff, reach out to us and we'll flip it to you via email. No problem there. We went ahead and got continuing legal education hours for this, and so there's a CEU icon at the bottom of the screen and a certificate of attendance. And also this webcast is being recorded, so if you signed up and weren't able to watch it, or you need to drop early, you can go back and watch the recording. And at the back we have a short survey. Okay, so I think that's pretty much the housekeeping items. In certain states, we have to do a survey for continuing legal education credits. So throughout this, we have 3 simple poll questions that are pretty simple, and so we've built those into our slides. Okay, so today joining me are my 2 colleagues. One is Pat Martin. Pat sits here in Kansas City and has been my longtime friend and colleague here in KC. We also have Molly Hobbs. And Molly started her legal career here in Kansas City, and she moved to Denver many years ago, and that's her hometown, and so she practices out of our Denver office. And both Molly and Pat, like me, we work in the benefits and executive comp space, and others in our group, and so we're glad to speak to you. I think that's going to be it. So let's go ahead and kick off the slides here and get going. So here's our agenda. And I kind of want to set the stage and spend just a few minutes and then really get into the meat with Pat and Molly. So I think many of us recall the bill that was adopted in December of 2020. And again, Pat and I were talking about this yesterday, and she had to remind me when COVID started, and then part of this was difficult. This bill is over 2,000 pages, and this was done right at the end of the Trump administration. The Washington, D.C. insurrection was on January 6th. We had an administration change, so I think it's putting us all in context. It's difficult, and it's in some ways it seems like yesterday. In other ways, it seems like many years ago. Okay. So what we're talking about today are legal changes and legal updates and provisions that were buried in the Consolidation Appropriations Act. So what's all the fuss? Again, more context here. In many ways, and we talk to clients all the time, and they we're talking about these issues, and some of it is sort of old news. And again, Molly will talk about this, but the mental health parity has been around since the 90s. And so in many ways, it feels like it's old news, and we've had to comply with these rules. But there's a lot of meat to the Consolidated Appropriations Act. And so we really wanted to take this opportunity to focus on some of the key plan sponsor action steps. Also, like you, we sit through lots and lots of seminars and listen to lots and lots of people talk on these topics. So I think hearing about it again and sort of getting our perspective will be helpful. So again, for context, we had a 2,000-page bill. The bill is written by divisions, starting with Division A, B, C, and so forth. And so we get all the way down to Division BB, which are the provisions impacting what we do, health and welfare benefits. Okay. And under Division B, there's really 3 titles, and we're going to be talking about bits and pieces of 2 of the titles. One of the titles was called the No Surprises Act, And then the other title is called transparency. And again, it goes back and forth. Some of the stuff that Pat's going to be talking about, we put under the no surprises caption, but it might be under title 2. But again, I just wanted to have this slide for context to help in your mind sort of put it into the table of contents. Okay. This stuff is complicated, and it's complicated for employers, and it's complicated for us because the way these bills are passed, the laws are changed, and then they're built into both ERISA and the Internal Revenue Code, and they're also built into the Public Health Service Act. And so in many ways, the statutes mirror, but they're amending 3 different laws, okay? And as we're focusing, our practice is focusing on the ERISA and the Internal Revenue Code aspects of it, okay? Again, as a reminder, the way that the ERISA stuff is enforced is through Department of Labor initiatives and audits, and then through participant litigation. Under the Internal Revenue Code, all of the group health stuff, including going back to the HIPAA days, the ACA days, all of that is built in the Internal Revenue Code, and there is a statute that 4980D of the Internal Revenue Code that assesses penalties on group health plans, penalties up to $100 a day for non-compliance. Okay. So one of the things that I'm going to talk about, and this is built under the transparency statute, and this is hopefully a brief reminder. So when we deal with retirement plans, 401ks and 403bs and such, we're all very familiar with the expenses and plan litigation and fee disclosure, and that's a very prominent area that we're all familiar with. Under the CAA, and there's a historical reason for this, but under the CAA, they've now they're trying to expand those same sort of fee disclosures to health and welfare plans, okay? And again, the way this is set up is under ERISA, a plan cannot enter into a contract with a service provider. But if a plan enters into a contract with a service provider and pays that service provider a fee, that is technically a prohibited transaction. And of course, that's nonsensical. Plans have to have service providers. And so under Section 408 of ERISA, there's an exemption that says, even though it's a prohibited transaction, we have an exemption. So the exemption for the service provider exemption is you can pay your service providers as long as you're paying them reasonable fees, reasonable compensation. And so the CAA has now built this in to the health and welfare space, okay? So beginning for contracts entered into after December 27, 2020, which is the adoption of the law, consultants and brokers are now required to disclose all direct and indirect compensation to us as plan fiduciaries. And again, it makes good sense. I don't think this is controversial. The consultants and brokers that we work with are probably have been doing this for years, but it creates a fiduciary obligation. And so now they have to do this. And one of I guess the only sort of controversial is not the right word, maybe the difficult word is a better word, is you have to disclose all direct and indirect compensation. And indirect compensation is defined, but a good example in the health and welfare space would be a consultant or a broker might receive certain overrides, additional commissions, if you will, or additional payments if they place insurance, all of their client base with a particular or meet certain thresholds with a carrier. Okay, so that's an example of indirect compensation. If you're an employer, a plan sponsor, you need to be aware of these rules, and you need to be talking with your consultants and vendors and brokers and making sure that you're getting this information. And it's a fiduciary issue. Again, it's required by the law. There is no particular format, and so it can be, again, people are taking different views on that, but the key is to get the information. Okay. This is a real simple poll question is go ahead and click yes or no whether sort of familiar with these, and you've received an updated fee disclosure from your group health plan vendors with respect to these new rules. And the rules commonly refer to 408B2 disclosures. So if you click on that, and I'm going to speed through this here. Because I want to cut to the chase. Good. So I clicked that pretty early in the, I think we had 38 responses out of over several hundreds here. So, but about 50-50. That's good news. Okay. So now I'm turning it over to Pat, and Pat's going to talk us through the No Surprises Act and some of the some of the stuff that fell under the transparency. But again, for context, this is all part of the Consolidated Appropriations Act that kicked in last year. Now, the one final thing, and I promise to stop talking, is one of the tendencies for all of us is to say, look, these are some technical rules, and our vendors and our carriers are taking care of this for us. And this is all built into their administrative procedures. That's true. However, don't lose sight of the fact that these are built into ERISA, and ultimately the plan sponsor, the employer, has the responsibility for all these rules, okay, with respect to their employer-sponsored group health plan. So even though it's true that our vendors and consultants may be helping us with this, it's the employer and plan sponsor's obligation to understand these rules and make sure it's in fact happening and document it. Pat, kick it over to you.
Thanks, Craig. I've got a lot to talk through, so I'm going to just get right underway and talk about a couple of the surprise billing rules. And the surprise billing rules really come in kind of two parts. One is out-of-network air ambulance rules, and the second is the out-of-network rules, which are out-of-network emergency services and then out-of-network providers at in-network hospitals or other facilities. So the No Surprises Act really took aim at air ambulance bills and says if you have an out-of-network air ambulance, the patient is only responsible for in-network costs, as it will be billed to the patient as if it had been an in-network provider. The air ambulance company cannot balance bill the patient. There is an arbitration process to determine the payment amount between the plan or the insurer and the provider. Because it is an out-of-network amount, there is no contracted amount. That arbitration process is currently in litigation. I'm going to talk a little bit about some other litigation going on, so we really don't know what's going to happen with the payment process. It may well be that there are some changes to that. There are also new rules for surprise billing for out-of-network emergency services, and you might be thinking, out-of-network emergency services, the old Obamacare Patient Protection Act took care of that. Well, really all that did was say that out-of-network cost sharing had to be the same as in-network cost sharing, but it didn't prohibit balance billing, and it didn't include anything other than true emergency services. So effective January 1, 2022, it expanded the definition of emergency services that have to be treated as if they're in-network to include post-stabilization care until the patient is able to be transferred to another in-network facility. From the patient's perspective, it is in-network cost sharing, so they are paying just as if it had been an in-network emergency service, and the patient cannot be balance billed. For ancillary services in an in-network facility. Now, we've all heard the stories of you go to an in-network facility, you think everybody's in-network, and you have surgery done, and lo and behold, you wake up and you find out your anesthesiologist was out of network and you have a huge bill. That has now been prohibited. If it's an ancillary service, and the ancillary services are listed there on the slide, the patient is billed as if it is in-network. So the patient only gets a bill for the in-network deductible, in-network copays based on an in-network schedule. The patient cost sharing is based on a recognized amount, which is either the state law amount or the lesser of a formula here, but the patient cannot be balance billed for any extras. Now we have the non-ancillary services, so services that are not on that list I showed you on the prior slide. For a non-ancillary services and in-network facility, the provider can only balance bill if the patient consents in advance. Generally, the provider has to give a notice and consent form at least 72 hours in advance if the service is scheduled, including a cost estimate. CMS has published model forms for the providers, and they have some pretty specific rules to make sure that the patient actually sees them, that they're not, you know, here's 27 forms I need you to sign right now before we can treat you type situations, so that the patient really does see what's going on. Now, the payment to the out-of-network providers by the plan or by the insurer, the parties enter into a 30-day negotiation period where they can negotiate back and forth as to how much is going to be paid. If that's not successful, then there's a baseball-style arbitration process. And by baseball style, it's the same process that they use in Major League Baseball. Each party comes up with a number, and the arbitrator simply picks between those two numbers. Under the regulations that were proposed, there's a presumption that for lack of a better word, the plan's term number is correct. So those arbitration rules were recently struck down by a district court in Texas, but with nationwide effect. So right now, there really is no arbitration process. I think they're waiting to see, you know, what's going to happen on appeal, what will happen with some other lawsuits, and then ultimately they may have to go back to the drawing board to determine this out-of-network payment process. So as an employer, what are you responsible for? And Craig mentioned some of this. For an insured plan, your insurer is going to handle the requirements for processing and paying all these claims. That's not something you as the employer do. But the employer is ultimately responsible for making sure your contract with the insurer requires compliance. The employer has to post a notice. The DOL has a model notice. We recommend that the employers post a notice in addition to, the insurer is going to put the notice on its website. We recommend that the employer post the notice as well, maybe on your benefits intranet site. And then employee education. The whole point of this is to protect employees. Employees need to understand what their rights are. And the statute doesn't really do a lot of good if you don't educate employees as to that notice and consent form, for example. For self-insured plans, again, your TPA is going to handle most of the requirements for processing and paying claims. But you as the employer are ultimately responsible and need to make sure your contracts require that compliance. Again, post the model notice on your website. And you may need to revise your plan's claims procedures. You have a plan document with claims procedures in it. You may need to look at that and revise those for those out-of-network claims. And again, employee education so that employees understand, so that employees can be better consumers of these services. Now I'm going to turn and talk for a little bit about the transparency rules. And there are 6 general requirements: insurance ID cards, good faith estimates and advance explanations of benefits, or EOBs, Gag Clauses, provider directory rules, putting publicly available machine-readable pricing information, and then reporting on pharmacy benefits and drug costs. And I'm going to go briefly through each of these. And I'm going to add, as I go through here, each of these have different effective dates. So some of these are currently effective, some of these won't be effective until later this year, some until in the future. So it's really kind of, compliance is really kind of a moving target. But in insurance ID cards, effective January 1, 2022, you must have an insurance ID card that discloses plan-specific deductibles and out-of-pocket maximums, and a phone number and website for additional information about getting network status. And those ID cards can be physical or electronic. The government agencies really haven't come out with regulations on these yet. They're just asking you to use a reasonable, good faith interpretation of what the statute says. So they aren't going to come in and say, no, your phone number and website aren't big enough on the card or whatever. They're really just looking for you to have cards with that information. And compliance on this, even though it says January 1, 2022, I will tell you is kind of lagging. I looked at my insurance card this morning and it doesn't have any of this information on it. So I've talked to our benefits people, and they're going to be following up. The next one is transparency and estimated date and estimated costs. And the effective date for this was supposed to be January 1, 2022. They have now delayed that until they are able to issue regulations. No information on when those regulations are coming, so we really don't know when this is going to be effective. But once it does become effective, the basic rule is going to be when a provider or facility notifies the insurer of the plan that a patient is going to receive a procedure, the provider or facility provides a good faith estimate of what that procedure is going to cost to the insurer or plan. The insurer or plan then has to provide an advance EOB, explanation of benefits, disclosing the following. Is the provider or facility in network? If not, how do you find an in-network facility? The contracted rate if it's in network, a good faith estimate of what it's going to cost sharing, and progress towards deductible and any out-of-pocket maximum. So for example, if the patient has already met the out-of-pocket maximum, you're going to say, you know, you've met your out-of-pocket maximum. Any medical management requirements, is there pre-authorization required? Step therapy for certain drugs, whatever. And then there are some stock disclaimers that will need to go on this. But again, they will be issuing regulations, and I think that's going to really flesh out what these advanced EOBs are going to look like. Another requirement has to do with gag clauses. Gag clauses are prohibited. This was actually effective on the date of enactment, so back in December of 2020. And what a gag clause is for this purpose is an agreement between the insurers or the TPAs and providers that prohibit the plan or provider from making price or quality information available to patients or others. For example, and I think we've all heard of examples of this, you find out, or the pharmacy doesn't tell you that if you pay out of pocket for the drug, it's actually cheaper than the drug's copay. Quality information, can plans tell you who the high quality providers are? So any kind of clause in a contract that prohibits that or limits that is now prohibited. Plans and insurers also have to have the right to electronically access what we call de-identified information, and that's the old HIPAA definition of de-identified information. And so you're supposed to go through and review all of your contracts and make sure that all of these clauses have been taken out. And it can be tough when you look through them. You might have a big stack of contracts, or you might have contracts that are written by lawyers and are very difficult to understand. Is this a gag clause or isn't it? And so what you might consider doing is what we call a catch-all amendment to an agreement. And that just says, notwithstanding anything else in this agreement, nothing is going to prohibit compliance with the Surprise Billing Act, the Consolidated Appropriations Act. Nothing shall be construed to be a gag clause prohibiting disclosure, rather than going through all of these contracts page by page and trying to figure it out. Each insurer or health plan, if you're self-insured, must attest annually to compliance with this requirement. They haven't told us yet how to do that attestment, but I would suspect that's coming out this year. I have a poll clause, or a poll question, and that is, have you done a gag clause review yet? And we'll give them just a quick minute for people to look at this, to answer. And the answer is no, 100%. I don't know how many of you have responded, but I think that's probably pretty accurate for most plans. If you're self-insured especially, I would urge you to get on that. Insured plans, your insurer is really going to be working on that. So again, this was effective back in December of 2020, so I would suggest maybe getting on that. Let's see, did I miss one? No, sorry. All right. Another requirement is accurate provider directories. Effective January 1, 2022, you must have an accurate provider directory. Insurers and plans must verify in-network status for those directories every 90 days. And if an enrollee, a patient or dependent, calls to inquire or sends an email inquiry, you have to respond within 1 business day as to whether someone is still in network. Providers are obligated to submit timely updates on their directory information, and there will be cost-sharing relief to enrollees who rely on inaccurate information. So that's really more designed to get to making sure that patients, dependents, whatever, can get quick and accurate information on who is and who is not in network. There are continuity of care protections that are statutory. You might be thinking, my plan already has this. We already provide for this. It's now statutory, and it's probably been expanded a little bit beyond what your plan says, document says. But effective January 1, 2022, and again, there are no regulations, so we're subject to a good faith, reasonable interpretation of these rules. Certain patients are entitled to continuity of care protections if their provider switches to being out of network. So you're pregnant, you're going to an in-network provider, your doctor says, I'm leaving the network while you're pregnant. Other conditions, serious or complex condition, they're going to have to define that. If you're inpatient, if you're scheduled for non-elective surgery, if you're terminally ill, the insurer plan has to notify the patient and inform them of their rights, and the patient can continue to receive in-network cost-sharing care for up to 90 days after the notice. The provider cannot balance bill and has to accept the in-network payments. Plan and insurer cost transparency, and this is something that's gotten probably some of the most publicity. And that is, this was originally scheduled to be effective January 1 of this year. They've now moved back the effective date to July 1. But insurers and plans must publicly release negotiated rates for in-network providers, historical out-of-network allowed amounts. The drug pricing information has been delayed indefinitely. And to meet these requirements, you have to disclose that information in machine-readable files that must be publicly available on the plan or insurer's website and must be updated monthly. There's a lot of question over what publicly available means. We've been kind of joking that we're going to put it on the front page of our firm's website. For your machine-readable file to get our information, click here. Some people are saying, if you don't have a website specific to the plan, you might not be required to do it. I don't think that's right. I think we need some more information on what publicly available means. Putting it on the plan on an intranet site that only employees have access to might not be enough, because then the spouses and dependents don't have access. Effective January 1, 2023, you must make price comparison and cost sharing estimates available on the internet, again, publicly or in paper form, for 500 specific items and services that are specified. And then effective January 1, 2024, it applies to all covered items and services. Reporting on pharmacy benefits and drug costs. The first report is supposed to be due on December 27, 2022. You have to submit data on benefits and drug costs annually, your data regarding your 50 most costly drugs, your 50 drugs with the greatest increase in costs, your total spending, impact from rebates or other amounts paid by drug manufacturers. So again, I want to talk a little bit about what are the employer obligations. For an insured plan, again, your insurer will handle most of the compliance. You really need to start determining where you're going to disclose those pricing files, those machine-readable pricing files of in-network and out-of-network amounts. You need to be obtaining, as Craig mentioned, those broker disclosures. Make sure your contracts with your insurance company require compliance. Determine whether your plan documents or SPDs need to be revised, and work with your insurer to get that done. Attest to your Gag rule compliance. And then employee education. The whole point of these rules are to make companies and employees better consumers. But if employees don't understand what's out there and what they can get information from and how to access it and how to use it, it's not going to serve its purpose. And for self-insured plans, again, it's basically the same thing. You're going to need to do the same things. And again, employee education, you as the employer may want to be using some of this information. going and looking at what other plans are charging for various procedures and use that as negotiation with your TPA or your insurance company. So the education part of this, both for you as the employer to understand what's going to be out there and what can I get access to, and to your employees, is really going to be the key to having this make a difference in terms of healthcare quality and cost. And I am now going to turn this over to Molly to talk about mental health parity.
Yeah, hey, this is Craig. I wanted to chime in here. Yeah, and I'm glad. Poor Molly. Sometimes we talk to these slides and she has to rush through her. So I think we're a good 30 minutes to talk about the mental health parity. I did want to have a quick transition here. I'm particularly sensitive to what we're about to talk about and what our employer responsibilities are. We're learning this stuff, and we're in many ways struggling like others. And we know that what we're going to sort of present to you, and maybe our recommendation may be inconsistent with what you've heard from other law firms or maybe your consultants. Big picture, I want you to take a step back, and if you're an employer plan sponsor, conceptually, although the mental health parity has been around for a long, long time, we think, in what Molly's going to talk about, is we think some additional steps need to be taken. If nothing else, gathering the information and having it in a good file. The key here to what makes me nervous is if you are selected for review, we would like our clients to be able to say, yep, we're on top of it, open the door, pull out a folder, and be able to demonstrate that they've thought about these rules and have gathered the information to demonstrate that they're compliant. Now, that's not to say the DOL wouldn't pick apart your analysis and all that sort of stuff, but at least you'll be able to do it. The last thing you want to do is be notified of an audit and be told that you have 10 days to respond and be trying to gather this information in the 10-day period, okay? So that, again, if you'll kind of think about what Molly's going to talk about in that context, that'll be helpful. Molly, I'll turn it to you.
Thank you. My name is Molly Hobbs. I am a partner in our Denver office, and I am going to talk with you all about mental health parity. So as Craig discussed earlier, we are focusing on the CAA and the additions it has made to the body of law that is mental health parity. And just kind of a short and sweet overview from the CAA. The CAA requires HHS, the DOL, and the IRS to request documents demonstrating compliance with the Mental Health Parity and Addiction Equity Act of 2008's non-quantitative treatment limitation requirements from group health plans and group insurance issuers. So even though I said that was short and sweet, that was a mouthful. There's a lot of acronyms. There's a lot going on there. So I wanted to, first of all, take a step back. There's my slide. And kind of take an overview, give some context on where we are in the mental health parity journey. So as Craig mentioned, this has been around since the 90s, just like fashion. Apparently the 90s are back. Mental health parity is still around. At this point, I just kind of wanted to walk through how all of this is laid out. So back in 1996, the Mental Health Parity Act came in. Under that, essentially the law says that there can be no lifetime or annual limits on mental health benefits that don't also apply to medical and surgical benefits. Flash forward 12 years and we get the Paul Wellstone and Pete Dominici Mental Health Parity and Addiction Equity Act. That's a big word. That's a lot of stuff. I've heard people call this MAPIA. I do not call it MAPIA, but just for context, some people do run around using that acronym. Basically, under this new, bigger, better iteration of mental health, it requires that plans that provide mental health and substance use disorder benefits cannot apply financial requirements or treatment limitations to mental health and substance use benefits that are more restrictive than those that apply to medical and surgical benefits. A few years after we get this 2008 rule, we get a couple sets of regulations. And I want to pause here and focus on these because these are actually pretty important to what subsequently comes out under the CAA. So under these two sets of regulations that at this point are a decade old, there's two big takeaways for purposes of our discussion today. The first one is that these regulations add a requirement that plans measure parity with respect to non-quantitative treatment limitations, or NQTLs. And that is a limitation on coverage that is not expressed numerically. My next slide here is actually a big list of them, but to provide a couple of quick examples on what an NQTL is, those are pretty specific, like medical necessity, or what are your in-network provider standards? So again, a limitation on coverage that is not expressed numerically. The second piece that comes out of, looks like Craig moved my slide forward. I'm going to move it right back. The second piece that comes out of these regulations is disclosure requirements. So under these regulations, you are required to document the standards and the factors that are used to apply the NQTLs in your plan, and you need to be able to provide them upon request when you receive a ERISA request under your health and welfare plan. So again, these regulations that have been around for a decade outline NQTLs, and they also outline disclosure requirements pertaining to NQTLs. Flash forward in 2016, we got the 21st Century CARES Act. That's not super relevant for our discussion today, but we got some additional compliance guidance and some audit requirements. And then here we are, 2021, we got the CAA, and that is what we are about to dive into today. Craig already flashed forward to this slide, but I included this in the deck primarily. I'm not going to read all of these examples. I think it's important to note that the regulations that outline NQTLs, this is a non-exhaustive list. So there could be more out there that are living in your plan that are not included in these, but this is at least a good start. This is what lives in the regulations, and I've included them here today just for your own reference. I am not going to read them. Moving forward, so again, here we are with the CAA. The CAA gives us new disclosure rules for NQTLs. Effective February 10th of 2001, which was 45 days after the effective date of the CAA, CAA says that plans must provide a NQTL comparative analysis showing that all NQTLs in the plan are applied equally to mental health and substance use disorder benefits as they are to medical and surgical benefits. And the CAA also requires regulators to request at least 20 of these comparative analyses per year. At this point, you might be wondering, well, what is a comparative analysis? Unfortunately for us, the CAA outlines 4 steps to completing your comparative analysis. So the first one is you go through and you need to identify the specific terms in your plan regarding NQTLs and describe the benefits to which each NQTL applies within each respective benefit classification. That term benefit classification is actually defined under the body of law that is mental health parity. Specifically, we've kind of got 4 big classifications. You've got inpatient, which includes in-network and out-of-network, outpatient, again, in-network, out-of-network, emergency benefits, and prescription drugs. So you look at all of your different benefit classifications in your plan and you identify the specific terms regarding NQTLs. The second step in the process is that you then identify the factors and evidentiary standards used to determine whether the NQTLs will apply. Thirdly, you then perform the comparative analysis to demonstrate that your plan is using these factors and evidentiary standards to apply the NQTLs to mental health and substance use disorder benefits as written and in operation, that they are comparable to the factors and evidentiary standards used to apply those same NQTLs to medical and surgical benefits in the same benefit classification. And lastly, you got to write it all down. So, that's totally easy, right? I'm sure you all are completely comfortable with that. So at this point in time, those of you that have fully insured plans, you're off the hook on this one. But for those of you that have self-funded plans, we are curious, have you started having discussions with your vendors about creating a NQTL comparative analysis? I will pause here for just a second. Okay, looks like we're getting some results coming in here. Give it just another second. Okay, so results are in, and by and large, the answer is no. I don't think that necessarily surprises us. Although we are now here to tell you that we're going to give you some really good reasons as to why you might want to start having those discussions. So, so we have now gone through what the CAA said, and I think when the CAA rolled out, it was a little bit jarring because these concepts of the NQTLs and how they apply in plans and the comparative analysis, all of that's a little bit gray area, and it's kind of hard to wrap your brain around. So subsequently, the DOL gave us some FAQs that came out about a year ago, and within those, I wanted to highlight 4 points or 4 Easter eggs in the spirit of the season. The first thing is that the DOL comes out and says that they're really not interested in like a broad brush statement that, yeah, we've looked at our NQTLs and they're totally compliant. They are looking for specific, for detail, and a reasoned approach. The second item is that the DOL says, hey, by the way, we're just going to remind you that we have this mental health self-compliance tool, that if you go ahead and do that process, it's going to closely align with what the CAA's new disclosure requirements are asking for. And I do want to pause here because I think that this is something that is a little bit overlooked. So the DOL on its website, this is something you can Google, has a self-compliance tool. It is an 8-step program. Step 6 is actually specifically targeted at NQTLs. I will say that it's not super intuitive and that it's kind of a lot to walk through the self-compliance tool, but that tool does in fact exist. It's on the DOL's website, readily accessible.
Well, Molly, I might add on that. It's amazing what you can find on the internet. You know, United Healthcare, again, this toolkit's been out since 2017, and I remember going to a DOL webinar and listening to it and coming back and sort of panicking, like, who's doing the compliance tools? And no one's raising their hands. In my folder, I have something that was done by United Healthcare. So you can find lots of things out there, but I would bet money that despite the toolkit being available, I would bet money that the majority of plan sponsors haven't completed that toolkit, couldn't pull that toolkit out of their folder saying, we've thought about it, we filled this thing out. And so that's kind of this is a reminder to us.
Yes, absolutely. And the one item that I was going to add about the self-compliance tool is that Craig's correct. This self-compliance tool, it's not new. It's existed for at least since 2017. So we've had this for 5 years, and the DOL is actually obligated to update it every couple of years. So they're a little misaligned with the new CAA guidance. So it was just updated in 2020. So it isn't specifically incorporated the CAA guidance, although it does specifically consider NQTLs. So that's something important to keep in mind. It is also cross-referenced in this new iteration of FAQ guidance that we recently got, or at least within the past year. The third thing I wanted to highlight in these FAQs is that the DOL does tell us specifically they want you to be prepared to disclose documents that support your NQTL comparative analysis. And those are specifically records and documentation that you're relying on. They say, pull together samples of covered and denied benefit claims. And I think importantly that if a plan delegates management of their mental health and substance use disorder benefits, to also keep documents related to mental health compliance with respect to your service providers. So the extent that you are having discussions with your service providers and you're asking them for information, go ahead and tuck those in your file as well. The fourth item that I wanted to highlight is that the DOL cut us some slack on this one because, as I said before, there's this non-exhaustive list of NQTLs that lives in the regulations. The DOL said, you know, we're going to cut you some slack. More realistically, they're cutting themselves some slack, where they're going to focus on these 4 NQTLs, which is prior authorization requirements for inpatient services, concurrent review for inpatient and outpatient services, standards for provider admission to participate in a network, including the reimbursement rates, and out-of-network reimbursement rates, i.e. methods for determining usual, customary, and reasonable charges. So we kind of got those 4, which you might think, well, that's great. That totally narrows what we need to focus on. Unfortunately, the DOL does add that you should be prepared to provide your comparative analyses for all of the NQTLs in your plan and to provide them on request. However, if you're just starting down the path of NQTL comparative analysis, I would suggest that perhaps these 4 are a really good place to start because we know that these are going to be heavy hitters. Okay, so at this point, this might be a tad stressful for you if you haven't really started thinking about the NQTL compliance thing. So you might be asking yourself, what happens if we are not in compliance? So this is the DOL comes in, they audit you, and they actually determine that your NQTLs are out of compliance. So the first thing that's going to happen is the DOL is going to give you an initial determination of noncompliance. That starts a 45-day timer for the plan sponsor to submit a corrective action plan and request in a revised NQTL comparative analysis. If you hand that over to the DOL, hopefully timely, and they still think you're out of compliance, you will then get a final determination of noncompliance. From there, once you receive that letter, you've got 7 days to call up all your participants in your plan and tell them that you are out of compliance with mental health parity. And then from there, if the public shaming of talking to all of your participants and admitting that you're out of compliance with mental health parity isn't enough, the DOL is then going to publish your name in a public record. They have to submit an annual report to Congress outlining their efforts for mental health parity. And yeah, you'll be listed in there as somebody who's out of compliance with mental health. So some of you might be thinking, well, this sounds a lot better than like tremendously punitive fines. Stay tuned on that piece. But the other thing that I will point out, being an attorney, is that some of our astute plaintiff colleagues will probably be monitoring which plans are found out of compliance with mental health parity and might be intrigued to talk with some of your plan participants. So I would say this kind of public shaming aspect is down the road punitive in that I think it probably significantly increases your litigation risk. Okay, so as I just mentioned, the DOL has an annual obligation to write a report to Congress outlining their efforts over the past year with respect to mental health parity, specifically this NQTL comparative analysis. We actually got our first iteration of this report this past January, and wanted to include some highlights from this because I think they're actually pretty interesting. So we know that the DOL requested the comparative analysis from 156 plans and insurers, 134 of those, so by far the vast majority were self-insured plans. Fascinating, none of the requested comparative analyses contained sufficient information upon initial request. So that's the DOL saying that they didn't really like anything that anybody provided them, which I am hoping, I think we are all hoping, is somewhat insightful for the DOL that most of us are not in a position where we're feeling really comfortable preparing these analyses. So I think optimistically, we're anticipating some new good guidance on how to prepare this style of report. The DOL did issue, we know at this point, they issued 30 initial determination letters of a finding of noncompliance, which triggers that process that was just featured on the prior slide, where they kind of dialogue and back and forth between the plan sponsor. Yet the DOL has not made any final determination determinations yet that we know of. However, we will be receiving another one of these reports in the fall. So to the extent that any plan sponsor has ended up on the DOL's naughty list, we'll probably know this coming fall. The other thing that came out of this report that we thought was pretty interesting was the DOL included some common deficiencies. So I think this is insightful for plan sponsors who have not been audited yet. Specifically, the 4 that we've included is a failure to document comparative analyses before designing and applying the NQTL. So what the DOL is saying there is that they actually want you to do this comparative analysis as part of your design process for the NQTL. They also said they really don't like conclusory assertions. So again, the DOL isn't looking for a broad brush like, yeah, we're in compliance with mental health parity, see plan document. That's really not good enough. They want really specific supporting evidence. They want detailed explanations. The last one is that they said that they got a lack of meaningful comparisons or meaningful analyses. So I guess when you're going through this process, to the extent you have to go through this process, I guess please make sure that it is meaningful for you and the DOL. Last number to throw out there for you is that there were 26 plans and insurers who agreed to the prospective changes. So some interesting insights coming out of that. What's on the horizon? So we know right now the 2022 report that I just referenced also includes a statement that I think from the DOL that pretty well summarizes the direction that all of this is going. Is that, again, we said at the start of this, mental health parity isn't new. The concept of NQTLs and these disclosure requirements have been around for a decade. They're new and improved as of last year. However, the DOL is now taking the position, and the Congress is now taking the position, the Biden administration is now taking the position that compliance assistance really isn't enough, and that they're going to start on really proactively enforcing these rules. The Biden budget proposal that came out a few days ago makes a vow to transform mental health and substance use disorder coverage, and they're really pro increasing enforcement efforts for the DOL. That is in line with and works in tandem with some proposed legislation that exists in Congress right now that would provide the DOL authority to make monetary penalties against plans and insurers for mental health parity violations. So again, this public shaming aspect, not to say that that isn't punitive, but we might be looking at public shaming plus punitive penalties. So stay tuned on that front, but that seems to be the direction that things are trending. Last slide here. So action items for plan sponsors. So as Craig started this discussion, this is challenging. So this has been coming out, it's like drinking from a fire hose. We've received a whole bunch of new information. The DOL is now expecting these comparative analyses that we don't totally know what they want and what they need to look like and how to do them. Again, I think we're really optimistic that we're going to receive some additional guidance, but I think probably the biggest takeaway we want you all to have from this is that we know right now that this is a really big compliance priority for the DOL. We know that they might be implementing additional punitive, actions in order to enforce this. The other thing we want to know is that these NQTL analyses are complex and they are lengthy. So to the extent that you haven't started talking about these or thinking about them, even though, again, fingers crossed, we get some good new proposed rules coming out. We get some new updates to the SelfCompliance Tool that kind of shows us how to walk through this analysis. But at this point, I think it behooves plan sponsors to really start thinking about this and start compiling documents and at least doing some really base level analysis so that if the DOL knocks on your door, you aren't completely caught off guard. So that concludes my portion. And I think we have a few minutes for Q&A, although I will let Craig, if you've got...
Yeah, I'll just go ahead and I'm going to kick this one over to Pat. So Pat, we've received a couple of questions sort of, and I think this is more of a clarification. Can you, at a high level, the issue the questions are getting at is who's responsible for this? And this is sort of the idea of, hey, it's in our SPD and our vendors take care of it. So can you speak to the employer, plan administrator / fiduciary obligation, kind of overarching to how it impacts all this?
Sure. Yes, for an insured plan, I mean, as we talked about with an insured plan, the insurer is really going to be the one who's going to do the bulk of the heavy lifting for you. And in a self-insured plan, your TPA is going to do the bulk of the heavy lifting. But ultimately, each health insurance plan is an ERISA plan. It's a welfare benefit plan under ERISA. And as a welfare benefit plan under ERISA, it is required to have a fiduciary. It's required to have a plan sponsor. The plan sponsor is going to be most likely the employer. But the fiduciary is supposed to be named in a plan document. And we'll be honest, most insured plans don't have plan documents separate and apart from the insurance policy. So if you're thinking, I don't have one, you and 99.9% of everybody else. But in theory, each plan is required to have what is called a named fiduciary that is responsible for compliance. Usually it's what we call the plan administrator, and typically the plan administrator is the employer. If you look at your 5500s, it'll say who's the plan administrator is the one who signs it. Again, it's usually the employer. Some plans have a special committee, especially self-insured plans will have a committee that acts as the plan administrator. So yes, the insurer and the TPA are going to do the bulk of your heavy lifting, but ultimately it's the employer's responsibility to make sure this stuff gets done. You're the ones who will be subject to penalties, and you may be able to say, okay, insurer, okay, TPA, you need to indemnify me under this agreement, or you need to step up and, deal with this. But ultimately, it's a plan document, and you're responsible for making sure that it complies.
Yep, and again, conceptually, even for fully insured plans, all of that rolls up under your ERISA wrap plan, right? And so your health and welfare benefit plan, the medical insured medical plan is often a sub plan or a component under the wrap plan. I think that's it. We're down to the last minute here. I want to leave everyone with a good taste in their mouth. We're positive about this. We feel like we're confident that our clients are in compliance with these rules, and their vendors are in compliance with the rules. Their vendors are monitoring this stuff and on top of this stuff. But employers / plan sponsors / plan administrators need to fulfill their fiduciary responsibilities and really gather this information and make sure that you've memorialized it and thought it through and talked with your consultants or lawyers, and you should go a long way. With that, we'll end our session. We want to thank you very, very much for your time this afternoon, and you guys have a great day, and let us know if we can be of help. Thanks.